And we can do state defense, state defense. What do you all want to do?
That's fine with the defense. I think many of the motions hopefully will be far shorter, and some of these issues I think have somewhat been dealt with the briefing, because as much time today as can be spent on things to make sure we have an orderly and good trial, I think are helpful. Some of those were raised in the middle and some were not, so that's a fine system, and we're going to hope, at least on the defense side, to move quickly.
Okay. All right, so let's take up okay, State of New Mexico's amended expedited motion to exclude defense witnesses Ryan Winterstern and Christopher Zook. You can use the lectern or you can, yes.
You might want to turn that microphone on.
And just so you know, so everybody knows, if you have a green light, that means your microphone's on, and if you don't want anybody to hear what you're saying, you want to turn that off.
May I proceed, Your Honor?
Yes.
Your Honor, the state filed this motion on June 26, 2024, after the defense disclosed on June 24th a witness by the name of Ryan Winterstern, and I understand he is one of the producers of this film. Mr. Winterstern had not been disclosed by the defense on any of their witness lists prior to June 24th. And while they argue that the state had Mr. Winterstern on its witness list in the Hannah Gutierrez trial, we would respectfully submit that that's a different issue. So here, the state did not have Mr. Winterstern as a witness. And so we understand that the defense is claiming that the reason they added him is because the state, at the last minute, added this producer theory. However, as the court, I think, noted in one of the hearings that we had previously, this producer issue was known to the defense, and in fact, during the grand jury presentation, and it begins at page 186 of the grand jury transcript, Ms. Morrissey questions the state's expert Brian Carpenter about Mr. Baldwin's role as a producer. And so this is not something that was new to the defense. Under State versus Lemire and State versus Sanders, the state is asking the court to exclude Mr. Winterstern because, number one, we have not been provided with the statement that he is going to be making or has made. We didn't have an opportunity to do a pretrial interview of Mr. Winterstern. So as it relates to this case, the state has no idea what he is going to be testifying about or any previous statements that he made relating to this particular case. Setting Gutierrez trial aside, the issue is, what is he going to say in this case? And because of the late nature of this disclosure, we'd ask that the court exclude Mr. Winterstern. With regard to Mr. Zook, now, while the defense is right, the state did not request pretrial interviews of law enforcement witnesses. They were made available. Mr. Zook was set for a pretrial interview, but apparently he has left the sheriff's department, so the defense canceled his subpoena and did not proceed with the pretrial interview. So he was not interviewed. We would respectfully ask that because of the fact that the state has not interviewed these witnesses, and particularly Mr. Winterstern was disclosed so late in the game, we ask that the court exclude these witnesses. And unless the court has any questions, Your Honor, we rest on the motion.
No. The court does not. Thank you.
Thank you.
Good morning, Your Honor.
Morning.
So we'll start first with Christopher Zook. As the state has already conceded, the state did not actually request a pretrial interview of Mr. Zook. It is something that they do have to request. The defense did set up an interview that was for our own benefit. We did inform the state that we had set the interview so that as a courtesy they could come if they wanted to, but it was not something that they requested. And if the party does not request the interview, then it is deemed waived. and at any point they had an opportunity to do so. I do have an exhibit to provide to the court. I also have a copy for the state. And so I do have an Exhibit A, which is to this motion, if I may approach, Your Honor. And what I've presented the court with is a series of emails that were exchanged between the parties. And these begin with the request that the state made for witness interviews in this case. And as the court can see, and as the state has already conceded, Mr. Zook is absent from their request. Now, the reason we've included these additional emails as well is because there were multiple occasions on which the defense actually asked the state if they wanted to amend or add any additional witnesses for whom they wanted to request pretrial interviews. At no time did the state then change their mind and say, yes, we want to interview Mr. Zook. And so that was deemed waived, Your Honor, and we canceled the pretrial interview that we had set for our own benefit for our own reasons. And so the state cannot now seek to exclude him when they did not take advantage of the process that was available to him. Additionally, with respect to Ryan Winterstern, it is somewhat ironic that in their motion, the state claims that the defense recently added Mr. Winterstern to gain some sort of tactical advantage, when really what we have here is that type of behavior on the part of the state. And one of the ways that we see this is that with respect to the initial filings before there was a dismissal in this case, when the case was originally brought before the court against Mr. Baldwin, originally, it had been clear that the previous prosecution team had intended to produce and to pursue a theory that involved liability based on a producer theory on Mr. Baldwin's alleged role as a producer. Based on that, we also then had a conversation with the new prosecution when they took over through Ms. Morrissey. And a conversation was had about the producer theory. And that was gone into in-depth and private conversations, at which point in time Ms. Morrissey indicated that she did not believe that that had that could hold any water, that it was a viable theory. Later, certainly there was the grand jury presentation. Now, there was really not much of anything related to Mr. Baldwin being a producer. They didn't call anyone who was on the set. There were a number of different producers. I believe it was 6 different producers who were actually on the Rust set. They didn't call a single one to testify. And so it was not clear to the defense. And the fact that it was unclear to the defense is apparent in the fact that we have an additional exhibit, Your Honor, if I may approach. And the exhibit that I've just now handed to the court, which would be then Exhibit B to this response, is an email correspondence between, again, the state and the defense, wherein, as the court can see, and I think the court will have to flip to the back page to see the beginning of the chain. And so on November 1st of 2023, the defense inquires and says, your target notice identifies 2 involuntary manslaughter charges on which you will be presenting information to the grand jury. We then proceed to ask that in order to ensure that the alert letter that we submit actually is efficient, that we don't waste everyone's time, that they identify the 2 theories that they're going to be proceeding on. The state, through Ms. Morrissey, then responded, basically just reciting the statute. We then asked and followed up on that to say, we assume that the producer theory is not going to have merit, and so you're not proceeding under that theory. There was no response. The state easily could have responded, could have let us know. They knew where our mind was. They knew that we were thinking, because of the prior conversations that we had had with Ms. Morrissey, that this was not a theory that they were going to proceed under. Additionally, Your Honor, with respect to the witnesses that they've listed in the actual case itself, and this again goes beyond just the grand jury, in the case itself, the state has not listed a single one of the producers who were on the Rust film. Not a single one. And so at this point, they have 3 different individuals who they're going to call to try to have them testify about what Mr. Baldwin's role as a producer would be on this film, what responsibilities he would have. 2 of those individuals have never been a producer before, and the other individual has very limited experience and was not actually on this set. So we sought, after the state had then disclosed basically for the first time to us their intent to proceed under this additional theory through some of the motion practice when we filed a motion related to one of their witnesses. They then first identified that they were going to move under this new theory. So we then, just a matter of days later, added Mr. Winterstern to the witness list, and it was for the first time. But this was because the defense was not on notice that they had intended to pursue this theory. And he was not on the witness list to try to gain some kind of tactical advantage. It was because he wasn't relevant due to anything previously that we understood the case to be about, which was, again, according to the indictment as well, it specifically lists the date of being October 21st, 2021. It does not list a series of dates. It doesn't list the length of time that Mr. Baldwin was on set. It lists one particular date. And so Mr. Winterstern was not relevant to the defense theory at that time. However, now we have added Mr. Winterstern, and the state cannot claim prejudice because Mr. Winterstern was a witness in Hannah's trial, and I'm almost finished, Your Honor. But not only that, he was the state's witness, and they did conduct a pretrial interview of Mr. Winterstern, and during that pretrial interview, it was actually asked by Ms. Morrissey what Mr. Winterstern's role was as a producer.
When was this pretrial interview?
This pretrial interview, Your Honor, that I have was January 8th of 2024. And so January 8th of 2024, he was asked a number of questions about his role as a producer by Ms. Morrissey. Ms. Morrissey also asked Mr. Winterstern about other producers' roles. Ms. Morrissey also asked about Alec Baldwin's role as a producer on set. And this is someone who would have personal knowledge of that, unlike any of the other witnesses that the state is calling to try to make out this producer theory. So there is zero prejudice to the state because everything that we would be going into in the trial has already been covered by Ms. Morrissey in their own pretrial interview for a witness whom they called in the previous trial. And so we understand that they're now trying to claim prejudice, but it's because that they know that this sinks their claim and that this is a much more appropriate witness than any of the 3 whom they've listed to try to go after Mr. Baldwin on this producer theory. So we ask, Judge, we are just asking for basic fairness and due process. There are other avenues. If the court wanted to give them another interview, they could do that. But again, they've already had a substantive interview of him, and we would ask that the court allow Mr. Baldwin to present this defense.
Thank you. Reply?
Yes, Your Honor. Thank you. Your Honor, the issue is the court issued a scheduling order in this case, not in the Gutierrez case, in this case. The court set deadlines for pretrial interviews. It set deadline for witness disclosures. And the fact that Mr. Winterstern was interviewed in the Gutierrez trial does not obviate the need to have a pretrial interview of him in this case. Because in Gutierrez, he was listed as a witness for the state. In this case, the defense is calling him. The state has no idea what he is going to be testifying about. The state has not been given any prior statements as it relates to this case. And as the court can see, Your Honor, what we have here is by this email is that the defense was put on notice, and they call it a producer theory. It's really not an independent theory of liability. What this evidence goes to, it goes to Mr. Baldwin's knowledge that his conduct on set was reckless, and it was in essentially wanton disregard for the safety of others. And his role as a producer made him keenly aware of the safety rules that apply on sets, what his responsibilities are. And so, as we'll argue in the 404 or the intrinsic evidence motion, this particular type of evidence is germane to the defendant's recklessness in order for the state to prove the involuntary manslaughter. They cannot claim that this is a new theory. As I noted, Your Honor, page 186 to 187 of the grand jury transcript, which was attached to the state's June 21st, 2024 response to the defendant's motion to file a supplemental brief, Ms. Morrissey goes into great detail with Mr. Carpenter, the state's expert, about Mr. Baldwin's role as a producer, his responsibilities as a producer. Mr. Winterstern, from what we understand, has very little producer experience, but nevertheless, we would argue to the court, Your Honor, is what is he going to be testifying to in this case? The state has no idea. That Ms. Morrissey spoke to him in the context of the Gutierrez trial is irrelevant to the court's analysis in this case. Under Lemire and under Sanders, and in Sanders, it's 1994 New Mexico Supreme Court 43 at paragraph 26. The court noted a defendant's right to present evidence on his own behalf is subject to compliance with established rules of procedure and evidence designed to assure both fairness and reliability in the ascertainment of guilt or innocence. If the state had done this, you know they'd be up here screaming to the court that we have sandbagged the defense. Your Honor, the state is entitled to a fair trial as well, and so we'd ask that the court exclude Mr. Winterstern. Thank you.
All right, the court makes the following ruling. The court denies the state's motion. With respect to Mr. Well, first, with respect to both of them, I don't think that you've established prejudice, and to the extent that you want them excluded, certainly there are other remedies. I will have the defense make Mr. Winterstern available for a pretrial interview. And with respect to Zook, I'm not quite sure now. They're saying they want an interview. All right. Is that a problem for you?
You can confer with the state and work out the issue.
All right. Thank you. All right. Remember, I believe it's 10 minutes aside, half an hour for lunch. So I'll start with move these. All right, state's motion in limine to exclude evidence or separate civil suits against defendant and or Rust Productions.